Hello and welcome to the Law and Life. I am Shashank Mishra, representing as a host with the renowned senior advocate of Supreme Court of India, Subodh Markandeji. This channel is an step of senior counsel to share his years of experience with the help of present issues. In this, we will be dealing with the episode number 52 on topic Power of the Speakers under the 10 schedules. I am curious to know how the Supreme Court keeps on interfering with the order passed by the speakers in the spite of clear provision in para 6 Clause 2, stating that the finality attaches to the proceeding 4. The Speaker relating to the disqualification of members under Para 6, Clause 1 of the 10th Schedule of the Constitution. Also, Para 7 enacts a clear bar to the jurisdiction of any court in regard to the matter of disqualification of the members under the 10th Schedule.
For this purpose of finding out why and how Supreme Court interferes with the decisions of the speakers, you will have to see Article 368, which relates to the amendment of the Constitution, and in particular, Proviso B to Clause 2 of Article 368. That mandates, that is, Proviso B to Clause 2 of Article 368 mandates that if an amendment to the Constitution seeks to make any changes inter alia in Chapter 5 of Part 4 of the Constitution dealing with the Union judiciary and Chapter 5 of Part 6 dealing with the high courts in the states, such amendments shall also require to be ratified by legislatures of not less than half of the states by resolution to that effect passed by those legislatures before the bill for the provision of such amendment is presented to the president for assent. So that's the requirement which was not fulfilled. So what happened that in Quixote versus Holloway versus Zikil Hu, 1992, Supplement 2 SCC 651, it has been held by the Supreme Court that Clause 7 of the 10th schedule affected the powers of the Supreme Court under Article 136, which is located in Chapter 5 of Part 5, and likewise it affected the powers of the High Court under Article 226 and Article 227, which are located in Chapter 5 of Part 6. Since the requirement of ratification by the legislatures of not less than half of the states before presenting the bill, inserting Part 7 of the 10th schedule to the Para 7 of the 10th schedule to the president for assent was not satisfied, Part 7 was void and unconstitutional. So that being so, that has been struck down. So there is no bar of jurisdiction in respect of matters connected with the disqualifications of a member of the House under the 10th schedule, that is Para 7. So that is how the Supreme Court and the High Courts are able to interfere with the orders passed by the Speaker in regard to the disqualification. And a large number of cases have actually been decided by various high courts and the Supreme Court.
So, what is the width of the jurisdiction of the Speaker under Para 6 of the 10th Schedule, and is there any other interesting case of interference by the Supreme Court with the decision of the Speaker?
This is a very interesting question, yes. Recently, a case has arisen. The 10th schedule of the Constitution confers power on the Speaker only, I'm emphasizing only on one topic, namely disqualifications. He has no power to say anything else. He has only, his power, extends only to one topic, and that is disqualification of members as laid down therein. There is a recent case, a very recent one, 29th of September 2022. They are in civil appeals numbers 5463 of 2015, I think there were a batch of civil appeals. It's the cause rightly is Gyanendra Kumar versus Bihar Vidhan Sabha. There, the speaker, while disqualifying four members of the House under the 10th schedule, he overshot himself and passed an order depriving them of their pension. So when this matter came up before the Supreme Court passed the order, whatever was required to be passed, with which we are not concerned. But Supreme Court specifically held that there is no provision in the 10th schedule empowering the Speaker to deprive the members of the House of their pension, or for that matter, anything else. His power is only confined to pass an order, either disqualifying or not disqualifying the members for the reason set out in the 10th schedule. So the Supreme Court held that the power of the Speaker is confined only to decide whether uh, they have incurred any disqualification under the 10th schedule. The, the Speaker has no other power. So they struck down that part of the judgment of the Speaker. So the pension is restored. So that's all in this episode. Have you any other question?
No, sir. Thank you, sir,
It's a very
for.
interesting
Mhm.
judgment. And your query about why and how the Supreme Court and High Courts are interfering is also answered. See, the persons in charge of doing all this must be aware that this is a there is a provision which requires to be ratified by the state legislatures of not less than half of the states. That having not been done before presenting the bill before the president for assent, the consequence is that 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 provision is unconstitutional because the process of constitution has not been carried out.
Yes, sir. Yes, sir. With that, all the question of mine will be solved. And thank you, sir, for informing and telling us all about it.
Thank you.